A hearty good afternoon to each and everyone, and welcome to the second edition of our Tobago West constituency virtual town hall meeting. It is our intention to do one of these meetings once per month, but we did one last week, the last Monday in November, and the intention is to do one once per month on the last Monday. But as we know, the last Monday falls during the Christmas season, and around the second week in December. So we wanted to do this and get this out of the way so people could get to doing their Christmas planning and so on. We have opened this session to everyone who's interested in joining. We had an advertisement on social media for the past week or so that people can know to join. So Tobago West, and it is all about representation and providing people with the necessary information that they need to make the right decisions, to remain informed about what is taking place in the constituency, and staying on top of items relating to our development. So I want to thank NIDCO for joining with us today. Last week we spoke about land title registration and land adjudication and so on in Tobago. And this week we're talking about the status of the Crown Point Airport project, the ANI Robinson International Airport project, which has been a very touchy issue for us here in Tobago. I can remember for as long as primary school, and even in my country days, Tobago crying out for an updated or modern airport. And when I returned home in 2008, the bulk of the conversation was about that. I remember reading documents and magazines in 2012 about the plans of the Tobago House of Assembly to reach out to the government for a refurbished and expanded airport. And it has been on the books in Trinidad and Tobago for as long as 30 years, but no government prior to this one had seen it fit or had come up with enough money or security financing to ensure that it happens. So we are at this place and at this point where this administration has taken the decision to go on with this project, costing over $2 billion. And we feel like it is an important investment for the economy of Tobago, for tourism in Tobago, and for the whole economic advancement of the people of the island and generating business activity within in Tobago. So we have here with us today from NIDCO, our NIDCO representative. I'll let her introduce herself, and we have people, we have lawyers in the house, we have members of the Tobago West constituency office who work diligently to ensure we bring the information and deliver good service to the people. We have some Tobagonian, Tobago West constituents in the house. Everybody, I see some members of the media also. So it's an open house, it's a virtual town hall meeting, so that you can be informed and have your say. So I'll hand the floor over to Miss Allen, who is a representative from NIDCO, and she's going to do a little presentation on the project and speak to some of the issues, and then we do a little question and answer forum, part of the forum. It's a 1 hour forum, and we started doing 1 hour, and if we need to expand to more time, we can do a part 2, or we can do extend the hours, but we're just testing it out with the 1 hour to see how it goes. Last week the 1 hour was sufficient, and this week we're going to see how it goes. Yes, so ladies and gentlemen, welcome. Thank you for joining us, and I just really want to thank you for being with us, and I hand you over now to Ms. Allen from NIDCO. Thank you.
Thank you, Minister Cudjoe. Good afternoon to everybody. My name is Onika Morris Alain, and I am the project manager for the Tobago Airport project that is being undertaken by NIDCO. NIDCO is the project management firm for this project. So I have a presentation, so I'm just going to share my screen. So can everybody see my screen? I just want to make sure that, that it is being seen. I see somebody has raised their hand. I don't know if it is that it can't be seen. Okay. All right, so the Tobago Airport project. So what is the project? So what you're seeing on the screen right now is a render, an architectural render of what the new Tobago Airport is going to look like once it is constructed. So the project is twofold. What you're seeing on the screen right now is what we call the main works, and that is the construction of a new terminal building in the Bonaccord area, along with all the associated airside work, which is what you're seeing here, where the airplanes are, and car parks, and an internal road system for the new terminal. So the new terminal will be designed to accommodate a capacity of 3 million passengers per year. To give you a sense of what that kind of processing that is, the existing terminal building that is in Crown Point processes 1 million passengers per year. So that means that we're looking at an airport really 3 times the size almost in terms of its processing capacity for Tobago. The design is being conducted in such a way that it will allow for sustainable development and future expansion. And so you can see it on the screen. I think it looks quite lovely. So who is NIDCO? Some of you all have been asking, I'm sure. NIDCO is a state enterprise, and we have been engaged by the government to procure the contractor and the consultants for the project. We are managing the project on behalf of the government. We are engaging with all stakeholders on matters affecting the project, and that will be stakeholders from the Tobago House of Assembly to the general public. And we are overseeing the land acquisition process. So that is NIDCO's role in this project. So where is the project located? You will see on the screen a blue square. That is the project site. You will see it is an area in Bonaccord that is adjacent to the existing airport runway. And it goes roughly from maybe Storbay Feeder Road, a little way off Storbay Feeder Road, to Gaskin Bay Road, and from Old Storbay Road or Storbay Local Road, as it may be known, to the airport runway. So that area that you're seeing is the area for the new terminal building and all the associated works. So you would have noticed by looking at this that we're looking at an area that has, you will see on the picture, that has lands and homes and things like that. So we would have had to acquire land. So what is the acquisition process that we are undertaking? This process is a 4-step process, really. Last year, persons in the acquisition zone would have been served with what are referred to as Section 3 legal notices, which is a notice under the Land Acquisition Act that says, hey, the government thinks that they might need to acquire your land for a public purpose. So once that notice was given, and it allowed us to make some determinations as to whether or not, yes, the land really needed to be acquired. So when we are sure that the land or the property needs to be acquired, a Section 4 legal notice would have been served. And these would have been served twice. So we served them last year, and then we also served them again at the middle of this year, about in June. We would have served Section 4 legal notices again. And what the Section 4 legal notice is that it says to the property owner, yes, we are definitely going to require your property, and this is our way of opening negotiations with you for the purchase of your property by the state. So everybody in the zone there would have received a Section 4 legal notice. That triggers a process of compensation, and what that process entails is a process of valuation, a process of negotiation, and then settlement and payment. So once we've completed that process, and that's a process that we're in the, I would say in the middle in, but we're actually past the middle of the process. Most of the properties have now been acquired and settled, and there are a few outstanding, and I'll show you later in the presentation where we are with the status of our settlements. So once all the properties have been acquired and everybody has been settled and paid, there's something that's called a Section 5 legal notice, which basically takes the properties and say, okay, well, these now belong to the state legally. So that is really the land acquisition process. And right now we're in the area called compensation. That's the process that we're in right now. With regard to the land acquisition policy of government, it is a twofold policy, with a part for NIDCO to play and a part for the THA to play. So in terms of the land acquisition process, NIDCO's responsibility through our consultants, and our consultants on the ground are ACQ and Associates. So they value the property. When you submit your claim as a property owner, because you will get your own valuer as well, and so the state has a price for your property, and you and your valuer come up with a price for your property, and that price that you and your valuer come up with is called your claim. So you submit your claim, and then once you have submitted your claim, NIDCO has a value for your property, and there will be a negotiation. And again, this is being done by ACQ and Associates on behalf of NIDCO and the state. There's a negotiation between us and the property owner, and that negotiation, you bring your claim, you state your case, we go back and forth, and then eventually you settle on a compensation amount that is agreeable to both parties. And once that is done, we go through a process of approving the compensation here at NIDCO and at the Ministry of Finance, and then it is paid. So that is done, the compensation is paid, and then we give the property owner a certain amount of time to vacate the property. So we have a second part of the land acquisition policy of government, which is for people who need to find somewhere to go. So these are people who are resident on the lands, or maybe have businesses there, as opposed to people who just own land and don't live here. These are people who have lands and businesses, who have houses and businesses on the property. And what has been done by the THA is the THA has developed lands at Shervan and lands at Cove that they're going to offer to persons who have been displaced by the land acquisition process for a discounted rate for a 199-year lease. So the THA's relocation committee is treating with that. This is separate and apart from NIDCO. I don't have all the details on that process, but I would be able to put you in touch with the THA office that is dealing with that. So going back now to NIDCO's side, the compensation process, as I would have mentioned earlier, there's a valuation process whereby both the state and the private owner come up with their values for what the property is worth. There's a negotiation process where the two come to the table and agree on a price, and then there's the settlement process where that price is approved by the Ministry of Finance, and then it is paid to the property owner. So this compensation process is the process we are in right now with the majority of the property owners in this area. So in terms of the valuation, we just to give some idea of how the valuations go. So in terms of the private valuation, an owner will obtain a valuation report for their property, and that will be their claim for compensation. So you get a valuer comes out and looks at your property, looks at your land, looks at your building, looks at your different things within your property, and they will come up with what they think is a fair value for your property, and you would submit that through ACQ to NIDCO. It's very important to note that when you have your private valuer, the state does pay the cost of your private valuer. So if you have a valuer, you don't have to find that money. The state does pay the cost of that valuer. So whatever your valuer is charging you, you will get that money from the state. Okay? So the valuer's job is really to quantify your claim under the recognized heads of claim, as they are referred to, and the next slide will show you what those are. And then they will submit their claim to ACQ, as I said. What we would like to encourage, if there are any property owners out there who are maybe watching today who have not yet submitted a claim, to please get a valuer and submit a claim. While a claim is not required, a claim does put you in a good position to have a conversation with us about what you really feel is the best value for your property. So we encourage everybody who is in the acquisition zone to get a claim prepared by a valuer and submitted to us. So I would have referred previously in the last slide to the heads of claim. There are three main heads of claim, under which there are a number of subheads, which we will not get into too much detail, but basically there are the things that the state can pay you for. They can pay you for your property itself, which is any land that you own and any building or structure that you might have on that land. If you are running a business on the property where you have lost income, or maybe you have to reestablish the business, or maybe you want to close the business down altogether, but you have costs to do that, you can make a claim for those costs. And then disturbance, which is loss suffered as a result of the acquisition. So for example, if you're living in the acquisition zone and you need to move somewhere else, but you have land, but you don't have a structure on that land as yet, one of the heads of claim under disturbance is an amount for rental of property while you are reestablishing yourself. So those are the kinds of things that can be claimed for under the disturbance head of claim. So in terms of the negotiation process, as I would have said before, the state does its valuation and you do yours. Then you enter into negotiations together. So the negotiation process, it might take one meeting, it might take several meetings to come to an agreement, but instead of being in a situation where if agreement is taking a long time, you're going through this and you don't have any compensation, you can in fact, as a property owner, make a claim for what is called an advance payment. There's a specific form, I believe it is Form J, and if you go to ACQ and you say, well, I don't think we can agree yet, but I would like to make a claim for an advance payment, you can fill out that Form J and submit it to them. They will submit it through to the state, and that is allowing for payment of up to 80% of the state's value. So this is not really in consideration of your value as yet, but in terms of this, if the state's value is, say, $1 million and your value is 1.2 and you can't come to an agreement, in the interim, you can make an application for an advance payment and we'll pay you $800,000 and continue the negotiation process. So no matter what, you've already gotten this $800,000, and then once you continue the negotiation process and say you agree now at, okay, 1.1 million, so between what we have offered and what you are thinking your property is worth, then at that point in time, you'll receive the balance. So the last $300,000. So 800 and 300 making 1.1 million. So that's the process of the advance payment. So then say you've done this advance payment, you had a tough negotiation, but you finally agreed on something. Once you actually make a settlement agreement, the balance of whatever is owed to you is paid at that time. So just a little bit more on the advance payment. So when can you ask for an advance payment? The state has taken possession under Section 4. In other words, these Section 4 notices have been received by the property owners. So at this stage, any property owner is at this point who has not settled as yet is entitled to make an application for advance payment. How much? As I mentioned, it's up to 80%. So not only 80%, but up to 80% of the state's valuation of the lands. So if you decide, well, I only need to make an application for 50%, that's fine. You can make an application of up to 80% of the state's valuation. And as I would have mentioned about the balance, when you complete negotiations and you've agreed on a final settled figure, the state will pay the difference between what you have already been paid as an advance and what you are owed as a settlement. So in terms of how you are compensated for your property, there are 4 main sort of categories that we have found in the area. So if you have title to your property, if you have a deed, if you are an owner of the property, you will receive the fair market value for your property as negotiated between you and the state. So if you occupy lands owned by a deceased relative, so in other words, you have a house on land that used to belong to your grandmother is now deceased, there was never a will or anything like that, but you know and everybody knows that that was your grandmother's land, right? So your structure is your structure and you will be paid for that, but the lands themselves, you will have to prove your entitlement to your deceased grandmother's land. So you are the grandchild, you can go to court and get a grant of probate, and at that point you would be paid for the lands. So if you own a structure on lands which you do not own, so for example, you are renting a parcel of land and you have put up a house on it, you will receive fair market value for your structure, and the owner of the lands will receive the market value for the lands. If you occupy a structure or lands which you do not own, so in other words, you are in an area which is there's a portion of the thing which are actually state lands already, and you're living in a structure on those lands, your case will be considered on a case-by-case basis in that regard. So if you don't have ownership, you will have to be considered on a case-by-case basis, but there is a certain amount of budget to deal with issues such as those. Okay? So as I mentioned, the third part of it is settlement. So the settlement starts when you agree on a price. Then once you've agreed on a price, it comes through to NIDCO and it goes through to the Ministry of Finance to approve the payment. And once that payment is approved, then the property owner gets paid. Once the property owner is paid, we will ask them to vacate, and I think we have been giving people at this point, up to this point, we've been giving people 60 days, I believe, but time is starting to run on us, so they are going to have to shorten that for some of the areas of the land, and I'll show a little bit later a map of where we are looking at in terms of certain deadlines. So once the owner has vacated the property, and all the owners have vacated, the lands will be vested in the state. But in the interim, in order for the contractor to start working, once the owner has vacated and told us, okay, I am gone, then we hand that over to the contractor and their work begins on that particular piece. So just a note on settlement. Once you have settled, you are allowed to remove any item from your home, and that includes things that are attached. So you can demolish the house yourself. You can take all your doors, your windows, your roofing material. You can take all your fittings and fixtures. Anything that you want to take, you can go ahead and take it. And when you can leave a shell for the state, or you could demolish it yourself, however you would like to deal with it, it is fine. And I just want to point out, it is the state's intention there will be no demolition of structures prior to payment of compensation. In other words, the state is intending that you will be paid before you have to vacate. So where are we in terms of the acquisition process? So we have a total of 127 properties in the zone, and I'll show you a map on the next slide. 127 properties. We have settled with 92 property owners of those 127. In addition, we have made advance payments. So 3 property owners have made a request for advance payments and are continuing to negotiate. And then we have awaiting claim or in negotiations. In other words, persons who may not have submitted claims yet or persons who are currently in negotiations with ACQ. There are 37 property owners in that regard. So you'll see that we're almost at 3/4 in terms of persons who have settled and been paid. Okay? And you'll see in terms of what that means in terms of the budget for those payments, that we have 55% of that we have settled in terms of the budget. We have used 4% for advances, and there's 41% of the budget that is still remaining. So the money to pay for these acquisitions is available, and it is being paid. So what are the deadlines for the process? We are at a stage now, we've separated the land into certain zones, and we are looking at deadline dates for those zones. So you will see where we have Zone A, the deadline is December 2020, but not to worry, the vast majority, I believe there are only 2 properties remaining that have not been settled in that zone. Everybody else has settled within that zone. So I think that by the end of December 2020, everybody would have been settled and paid in that zone, and we would be handing that zone as a whole over to the contractor. And you would see, so that is the zone between, I believe it's Silk Cotton Terrace, I'm not sure, I think that's what it is, Silk Cotton Terrace, and roughly Crumpston Road. That zone, the vast majority of persons in that zone have been settled. Then the next deadline that we're looking at is February 2021, and you'll see Zone B, which is roughly between Crumpston Road and Sunset Apartments, which, if you know the area, would have been settled and demolished within this last month. So that zone, we are looking at February 2021 for everybody in that zone to have been settled and paid and vacated. Zone D is an area which is actually state land, but there are, of course, persons living on the lands, and we have to deal with and treat with those persons, as I would have mentioned, on a case-by-case basis. And we're in the process of starting up to deal with negotiations in that zone, and we're looking at having that zone available by February 2021. There are not that many people in that zone, so we think that that's a very a doable date. And then Zone C, which is the last, the zone over there in the yellow, that is between Gaskin Bay Road and Silk Cotton, I think it's Silk Cotton Road or Silk Cotton Trace, I'm not sure. And that area, we're looking at March 2021 to have all persons in that area settled and vacated. So these are the deadlines that we are currently looking at, and these are based on the contractor when we will need to hand over these particular areas to the contractor so that they can start the construction works. So if you would like further information about anything about the project, the land acquisition, or the project itself, our community outreach office, we would have moved a little earlier in the year. So we were previously on Milford Road at the Taxi Cab Cooperative building. We are now at our own project office, which is opposite the airport, down towards the end where the cargo handlers are, Swissport and such, down towards the end of that road. That is where our new offices are. And the telephone number and the email address are there. In case anybody wants to get in contact and find out any information about the project or the process, or wants to be put on to the THA Relocation Committee, the persons at the Community Outreach Office will be able to assist you in getting that information. And that is it from me. I will take questions now if anybody wishes to ask any questions.
Thank you very much, Ms. Allen. Thank you for such a comprehensive report on the state of the project. At this point in time, as Ms. Allen would have indicated, we'll open the floor for questions. You know, we have members of the media, we have some residents in, and interested constituents. Please feel free to ask your questions at this point in time. Thank you. This is very strange. Anybody has any questions for our presenter today on the status of the project? I want to ask a question. When during the July-August period, I had some people who would have raised the issue that they would have gotten the evaluation and then had an agreement with NIDCO, gone through the whole negotiation and so on, and then what they agreed to is not what they got. And I found that quite strange. Could you explain the process as it relates to that? So let's know, is it possible at all for somebody to agree to a price, agree to a claim? What do you call the settled price? Sorry,
the settled price is called this.
It goes from a claim to a,
yes.
Right. So when you agree to a settlement amount, is it possible to receive less thereafter? So could you explain that? What do we have in place to ensure that the person receives the amount that they have agreed to accept? Is there a contract? Is there a document? How can I prove that person wrong?
Right, so everybody who settles with us will sign what is referred to as a letter of offer in the first instance, and that letter of offer would state what the price is, and it would break down the price in terms of what it's made up of. So say I have a house on a parcel of land, the letter of offer would say this is how much the land is going to be paid, this is how much is going to be paid for the house, this is how much is going to be paid for disturbance, this is how much is going to be paid for my valuer, etc. And then it will have a total figure at the end. That letter of offer figure is the figure that is sent to the Ministry of Finance for final approval, and then that figure is what is paid to a property owner. Now, what may happen is that if you have a structure, so a house or a business or anything other than raw land, what we will do is we'll pay that settlement in parts. So we'll pay you 80% of the settlement up front so you can make your arrangements to move. And then when you have vacated the property and tell us, okay, well, I'm out of the property, I've removed everything that I wanted to remove, then that last 20% is paid to you. But when we do this by check, for example, we'll prepare the checks for the full amount at the same time. So the 80% check and the 20% check are both there, so that when the property is vacated and you say, all right, I'm gone, you sign what is called an indemnity agreement at the 80%, and then at the 20% you sign what is called maybe a chattel receipt, and those documents will say, all right, I have agreed to be paid this amount of money, I'm receiving this amount now, and I'm receiving this amount when I vacate. And then the chattel receipt at the end is how you prove that you have vacated and you receive that money at that time. So you receive 100% of what you have settled and agreed to. You receive 100% of what you have settled and agreed to.
Okay. Thank you very much, Ms. Allen. There is another question or concern that I wanted to raise. This arrangement where I know usually in land acquisition, when we acquire land from private citizens for public good, we compensate at the settlement price, and that's it. Now it's the responsibility of the private citizens who would have received the monies that they would have agreed to receive to go out and find accommodation elsewhere, or probably open a business or send their children to college or buy a new car or whatever they want to do with their money. This arrangement with the Tobago House of Assembly to provide subsidized land or subsidized property, or property at a subsidized price for those who are interested. This is something new and unique to Tobago.
This is something that is an initiative of the THA as part of their social responsibilities on the island. So this is something that the THA came up with as a part of, as I said, as their social responsibility. They identified the lands, they have developed the lands, bringing them up to scratch in terms of providing electricity, water, sewer, etc. They have subdivided the lands, and they are offering sale of these long leases at a heavily discounted price to anybody from the acquisition zone who is interested in moving into one of those areas.
But it is not something that you have to take. You have the option of taking it if you like, or doing what you want with your money. Okay.
Yes, it is an option. So it is an option being offered by the Tobago House of Assembly.
Okay. Is there anybody else that have any questions, any concerns? We have 16 minutes left in our 1 hour segment. Please raise your questions, and we'll be more than happy to answer or go out to find the answer so we can respond to you at a later date.
Hi, good afternoon. I have a question. I have two questions actually. Good afternoon. How would these notices disseminated? Because I am living in where you would have put on the map zone D, section D, all right, and we would not have ever received any notices. So how would these notices have gone out?
Okay, so with regards to Zone D, you would have heard me mention that Zone D is an area of state land. So this is an area that was previously acquired by the state and actually belongs to the state. So no notices would have been issued in that area. So the way that we have to treat with that particular area is to come in and speak to people directly and negotiate with people on the ground there. But we cannot issue a legal notice with regard to that, because under the law, the state already owns those lands. But that is a thing where we are now getting into the, it had to be dealt with by the Commissioner of State Lands. The Commissioner of State Lands has now asked us to look into whether that we can actually, as we are already on the ground, come in and speak to people. So that is being arranged. So it was previously being dealt with 100% by the Commissioner of State Lands. The Commissioner of State Lands has now asked us to assist. So at some point within the next couple of weeks, we will be coming in, ACQ will be coming into that area to speak to persons residing in that area labeled Zone D, because you are correct, you would not have received a legal notice, and that is because under the law we could not have issued a legal notice to you, as under the law those are technically already lands belonging to the state.
Yes, good afternoon everyone.
Good afternoon.
I have questions / comments. I only clarification regarding the land acquisition policy. You indicated in your previous slide that it is two-pronged, NIDCO and THA.
Yes.
One holistic policy, or is a policy where the two entities are independent of each other? Asking because you said you're not clear with the particular detail, but you can refer to get the particular detail. I'm just thinking a policy so that the resident
with the detail.
Okay. So those two things are being handled separately because the THA's lands are under the ownership of the THA, and the THA would have been undertaking the development, and it would be the THA who would be issuing these leases. NIDCO does not own the land, so NIDCO cannot be involved in that particular process. NIDCO can only be involved with the process as is instructed by Cabinet, which is to value the properties that are being acquired, to settle with property owners, and to pay those property owners. But all matters dealing with relocation, anybody who wishes to take their compensation and avail themselves of what the THA has on offer, that is a separate process. However, we are working sort of together on it. So if you call our outreach office, they will be able to put you in touch with the relevant persons at the THA who can do that. The THA's office for the relocation is also in the taxicab building where we used to be. So taxicab cooperative building on Milford Road, which is opposite, sort of obliquely opposite FCB. So in that building, that is where the THA's relocation office is, so you can visit them there. I do not have the number, unfortunately, but if you call our outreach office, they have the number. Yes.
Policy is actually, in terms of NIDCO, the policy is the actual check. That's it, full stop. Yes?
Yes, that is correct.
Okay, I heard that it's a unique arrangement, but then you're saying the NIDCO situation is actually the check. So it's not necessarily a unique arrangement, but as you did share, THA is doing a social responsibility by offering that. I'm aware in terms of land acquisition in the past in Trinidad and Tobago where, well, I mean, we have heard it over and over, the Piaco development when that was acquired, resident open garden was developed for those residents. So in terms of one saying unique or even precedent to have resident relocated before resettling. But I saw your stats in terms of your percentage of those already settled and those being negotiated. And thanks for sharing, giving that sort of breakdown and update.
I want to add that what would have happened in the case of Orokun Garden, why I said it is unique. Unique probably is the wrong word. It is not the law. It is not the law to do that. The law states that in the land acquisition process, you acquire land, you compensate the people, and then there is no law that says you must do X or you must do Y. So it would be the social, based on social responsibility, based on the concerns and the situation relating to the residents or the people who are being displaced. I'm just saying it's not in our law that has to happen, and therefore you are not breaking any law if you don't accept taking that piece of land or pursuing, acquiring, getting lands from the THA. You can do what you want with your money when you receive your money. You don't have to go and live there. If you feel like you want to take your money and go and live up in Charlottesville or Salmon Grove or wherever you want to send your child to school, you're free to do that. So you're not confined or bound to take land from the government. It's just an option based on social responsibility for those who are interested in going that way, based on my understanding of it.
Excellent, very excellent. And I do agree that it's not law. I endorse the point of the social responsibility. And that's why I underscore the open gardens, so that there are some residents who would have liked to see that social responsibility executed in a similar manner, while yes, one has that freedom of expression of land, car, house, but as financial, some financial guidance, we tend not to ask one to exchange fixed assets for short-term perishable. So I would hope none of the residents would take their funds for perishable items like cars. Of course, there are other, other assets well set to ensure their generation and that inheritance to develop Tobago and their family.
Yes. Thank you very much. Is there anybody else who wish to ask a question, make a comment on the matter?
Pleasant evening.
Hi, Mr. Lovell.
Yes, family. Well, A and B, I'm on the D side, with section 45, and now I understand that we are saying that these lands acquired in 1996, which I have my deed stating 1995 involving Lovell's name. I was living here in 1988, and then I don't understand why we are saying that these lands acquired. I don't know anything, which no one contact me, which my land registered and all that in my name. And people are trying to talk that all the land acquired, and you're spotting on government land, and which I don't understand, because I received a section 3 notice, which after they were saying my land acquired and so on. The very said PHA make a search and they realize that my land was registered in my name. I have town and country approval, all this. And still, yes, people saying my land acquired. I don't understand this. So family, I want you to look into that, Yeah, thank you.
Thank you, Mr. Lovell. In terms of that particular area, as I said, we are going off the documentation that we would have, but all of these things are being looked at by the Commissioner of State Lands, and as I would have mentioned, they would have also asked us for some assistance now. So persons from ACQ at some point over the next 2-3 weeks or so will be coming to speak to everybody who is in that area, what you would have referred to as parcel 45, what I would have shown as zone D on the map, and we'll be coming to actually find out, what is what. So I am only speaking in terms of what documentation that we have seen, but we are not shoving anybody off. We are making sure that we get all the relevant information, and that if there's anybody on those lands who has not been previously compensated, will be compensated.
Thank you very much, Ms. Allen, and thank you, Mr. Lovell. I would like to open up for anybody else who has a question or would like to comment as we get ready to wrap up the session. This is our last 5 minutes, so please take the opportunity. I know this has been a burning issue in Tobago over the past year, past couple months. Now, come on, just because the election has passed doesn't mean it's not a hot topic anymore. I'm sure you all are still interested in what's going on in that area, and we want to know. And it is our business as the Tobago West Constituency Office and my business as MP. This makes my work easier to bring the people who have the information and to share the knowledge with you, because it's not just about going house to house to find out who want X or who want Y or who want Z, but it's about keeping constituents educated and informed so you can speak eloquently and confidently about the matters or the developments taking place in our constituency, and you can make decisions and plan your lives accordingly. So this time is your time. If it's necessary to have a part 2 later on, of course, no problem. But if you think that this one session is sufficient, then we'll wrap it up. So I'll ask one more time, anybody, any questions, any comments as we wrap up? Going once, going twice, gone. All right, my dear constituents of the Tobago West constituency from Scarborough all the way to Crown Point, it was indeed a privilege to sit with you this afternoon and to bring this information to you. I want to thank Ms. Allen from NIDCO for really responding to our request May 2 weeks ago, asking to come on board and do this session for us. Thank you for being so informative and presenting this PowerPoint presentation that was done so clearly, so concisely, and so comprehensively we all can understand. I want to thank the residents who are affected in the area for joining us, and the media, the Tobago West constituents. We have some lawyers in the house too. So we have to keep the fire burning. We have to stay on top of our business and on top of our issues so that we can really make our contribution to Tobago's development and take Tobago forward. I would say, like I have always said in this whole process, the power is in the hands of the residents, and it is their business to sit down and negotiate and come to a settlement price that they are comfortable with. Nobody's going to force a settlement price down your throat. At the end of the day, you get what you signed for. Ensure that you educate yourself, that you get the necessary advice, that you remain informed. And when you sit down to negotiate, take all things into consideration and negotiate the best price for you and your family. Yes, so we as government, we stand ready to assist, we stand ready to support, and we stand ready to serve. So ladies and gentlemen, special thank you to Ms. Allen. Special thank you to the Tobago West constituency office staff. Just really want to thank everybody for joining us this afternoon. We will have had at least 30 participants at one point in time on the live, and I think that's a good turnout. Last week we had over 50 participants when we were dealing with land adjudication. But we continue to record these presentations and then post them to our Facebook account, Shamfa Cudjoe MP for Tobago West constituency. And we continue in our journey to serve Tobago West, keep you all informed, and to represent you with distinction. So I want to thank you. I bring this meeting to a close. God bless all of you. Have a good evening.
Good evening, everybody.
Good evening.